Shalom, shalom, shalom. This is your Ark. Yah is magnified, and I'm back with another informative video. I titled this video, Failure to Respond and or Appear After Having Been Properly Served with a Summons and Complaint Equals Default Judgment. But before I tackle this subject, as always, I must state for the record, I'm not a lawyer, I do not practice law, and I do not pretend to. All my videos are for informational and educational purposes only. They're all facts and all truth. Nothing more, nothing less. So with that being said, guys, let's get to it. Okay, so now, as you all know, I've been doing a continuous series of videos on why it's a must that you all respond back. All right. So now you have individuals teaching you that because someone sent you mail and you sent that mail back, you just avoided process service, which is far from the truth, guys, which is far from the truth. Sending the mail back do not void process service. Why? Because you must understand what being properly served deals with and what the methods are and the methods that are being used to properly serve you. Mail is only one of the methods that they can use. There are multiple methods. There are alternative methods of service that I showed y'all in my video titled Alternative Methods of Service. But let's continue forward because the individual that's putting out that nonsense, his new argument now is using the child support glossary terms, right? Now understanding that he can sit back and quote a definition, but he doesn't have any understanding of what he's quoting. And like my Ark said, even though it's common sense to a lot of people, but common sense is just not that common. All right. Cause you have, like I tell you all, man, you have well-known federal agents on YouTube who's out here to simply mislead you guys. All right. Everything I'm telling you all are facts, supported by documents, supported by court orders, supported by everything. But this individual come on there and give his interpretation of a definition and think that he's telling the truth without any support information backing up his interpretation of the definition. The definition is not for private interpretation. But that's what he don't understand. The definition is not for private interpretation. So you're not going to get these definitions or interpretations of definitions from me. You're going to get the interpretation of definitions from the court and what the courts are ruling. Okay, that's the difference between me and him. But let's continue forward. This states what? Default. Since he want to read this and he want to quote this, let's read it the right way. Let's get right wisdom, right knowledge, and right understanding of what's being said. This states what? Default. The failure of a defendant to file an answer or appear in a civil case within the prescribed time after having been properly served with a summons and complaint. So the key word is, how is one properly served with summons and complaint? That's the key to this whole thing. So now let's stop right there and find out how is one properly served with summons and complaint. Let's go there. Okay, so now as you all can see, we're coming from Cornell Law School. This is a simple internet search that anybody can simply do. All right. Just type in Google, serves the process to get understanding of what's going on. All right. For certain information, you don't have to go to the law library just to get certain information. That's what the internet is for. You can simply Google these things from your own comfort in your own home to get understanding of what's going on. All right. Don't take my word for it. Let's read what Cornell Law School states. Serves the process, right? Let's read it. The Due Process Clause in the United States Constitution prohibits courts from exercising personal jurisdiction over a defendant unless the defendant has what? Proper notice of the court's proceedings. To meet this rule, courts require plaintiffs to arrange for defendants to be served with a court summons and a copy of plaintiff's complaint. These papers are collectively called process, right? Let's continue. Typically, it is not enough to simply mail process to the defendant. Now, didn't I just tell y'all that? Didn't I just tell y'all? But let's continue. The summons and complaint must be either given directly to defendants or left with a suitable person at their home or place of business. So you can send the mail back all you want. They're going to serve you, meaning they're going to serve someone at your address, right? Or they're going to hand you the documents. Either way, when someone receives them on your behalf, you mail them back, you've been served, so you waive due process. If you receive them yourself and you send them back, guess what? You've been served and you waive due process. All right? And you will be held in default when you don't show up to court. Don't take my word for it, guys. This was called supporting evidence. Whenever you go to court, you must have supporting evidence to support everything that you're saying. This is what the individual don't understand. He is going off of his own private interpretations, not having any clue of what's going on. But let's continue. Well, oh, here it is right here. Let's pick this up at the top line. Typically, it is not enough to simply mail process to the defendant. The summons and complaint must either be given directly to defendants or left with a suitable person at their home or place of business. Service may usually be performed by an adult who is not a party of the lawsuit. Plaintiffs may hire personal process service to serve defendants. Let's continue. There are exceptions to these general rules. For example, the federal rules of civil procedure allow defendants to waive in-hand service of process. Defendants who do so get more time to compose their answer. Those who refuse must compensate the plaintiff for the cost of arranging for an in-hand service. See Rule 4D of Federal Rules of Civil Procedures. Rules govern service of process vary by jurisdiction. Okay, so now as you all can see, basically that's simple. Jurisdiction don't start when you receive mail. No, you can send all the mail back all you want, because the only thing they're going to do is properly serve you. Meaning what? They're going to have someone serve the documents to you. And if you're duck service, then guess what? They're going to go to all the other alternative methods, such as service by service by publication, or simply asking the court, can they just affix a copy of the summons on the door? After that, you are considered to be served. Stop listening to these internet gurus out here who don't have any understanding of what's going on. That's why I tell you guys, that's why they cannot show you their case being dismissed. They cannot show you any victories because they don't have basic comprehension skills. And it's just that simple. But let's continue. Let's go back to where we left off from. Let's continue reading. Let's go back to the definition for default coming out of the glossary of child support terms so we can get better understanding of what's going on. Let's go back there. Okay, so now as you all can see, we're right back at the glossary of child support terms. Let's pick this up at the second sentence in the definition for default. It states, the tribunal, hearing the case, can enter an order based on information presented without any challenge if the responding party does not answer the claim or appear in court as requested. Okay? So do you guys understand that sentence? That sentence is basically stating that once the person has been properly served with the complaint and summons and they do not show up to challenge or rebut the presumptions on and for the record, then the court will enter in a default order against them. Okay? That's why the last sentence says, this is called a default order. Okay? But let's continue. It clearly states right here as well that the individual, he highlighted this. I just screenshotted his screen just to show you all, to go back over the nonsense that he was trying to teach you all. But it states, appear in court as requested. Of course it's as requested. They cannot force you to appear. They cannot force you to take your due process. No. You can waive your due process. And you waive your due process by not speaking when you have a legal duty to do so. And it's just that simple. So now let's read the next definition, which is default judgment. Decision made by the tribunal when the defendant fails to respond. Okay? So again, when the defendant is properly served with summons, and if he send that summons back, okay, if he do not respond to that summons, right, then guess what? He was properly served and the default judgment could be entered in against that individual. All right? It's just that simple. But now let's go to a place in this dictionary that the other individual did not go to, okay? And this is called service by publication. Let's go there. Okay, so we're going to pick this up right here where it states service of process. Okay, because this is the part of the glossary of common child support terms he did not go to. This the section over here he avoid. Okay, why? For he can only mislead you all. Alright, don't take no one's word for it. Do your own research. And you will find out that everything y'all's magnified is saying is all facts, all truth, all proof. Nothing more, nothing less. That's why I tell you all that at the beginning of each and every one of my videos. But let's continue. It states, service of process. Let's read this definition. It states, the actual delivery of legal paperwork that requires a person to respond or appear to that person or his/her agent. So service of process is what? actual delivery of legal paperwork, meaning that someone is going to have a process server or someone not a part of the case to come and serve you documents. And once you receive those documents, you have been served. Once you have been served, that person serving you will fill out an affidavit solidifying that under penalty of perjury that they served you these documents. And if you don't show up, guess what happens? A default order will be placed against you. And it's just that simple. But that also, let's go to what we came here for. Service by publication. Let's read that. Service of process accomplished by publishing a notice in a newspaper or by posting it on a bulletin board of a courthouse or other public facility after a court determines that other means of service are impractical or have been unsuccessful. Okay, so once they figure out that you are ducking services, they will go to what? Service by publication or any other alternative method to properly serve you, so they can retain jurisdiction over you. Now, if you choose not to show up after you've been properly served according to them, then they will default you. Why? Because you simply waived your your own due process, and it's just that simple. But let's continue. This method of service is not available in every jurisdiction. All right. So now, let's continue on to more service of process. Like I tell you all, let's get better understanding of what's going on. Let's put this thing to bed once and for all. Let's put it to bed. Let's continue on. Okay, so again, we did another simple internet search because that's all you have to do. Okay, you don't have to go to the law library to get this simple information. All right, even though it's good to go to the law library, but you don't have to get simple information such as this. All right, so as you all can see, we're coming from law.jrank.org, right? Let's continue further. Service of process. Methods of service. Let's continue further. 3 basic methods are used for service of process. 1, which is the first method, is what? Actual or personal service, meaning what? Someone actually delivered the documents onto you and handed them to you in your hand and walked away and said you have been served. Okay? Or 2, substitute service, meaning what? That they serve someone else on your behalf. Or 3, or should I say, and 3, service by publication. Exactly what we just read, meaning that they can place an ad in the newspaper, informing the public that there is in fact a case out for you. And if you do not respond back or you do not appear at the court hearing after the ad has ran, then guess what? The court will hold you in default. And it's just that simple. Let's continue further. Although each method is legally acceptable, personal service is preferred because it is the most effective way of providing notice, and it is difficult for the defendant to attack its legality. You see that? So the only way that they really respect you being served is someone handed to you. That's why that's the main thing used, which is personal service, because it's hard to attack personal service. Okay? Let's continue on. Personal service means in-hand delivery of the papers to the proper person. Traditionally, personal service was the only method of service allowed by law because it was the best suited to give the defendant notice of the proceeding. That's all it is notice of the proceeding. Once you receive notice of the proceeding, then you just did what? Received due process. And it's just that simple, right? I'm not going to go over the other ones. I just wanted to show you all that, but I'll pause it for you all can read it. You know, pause it, read it. Pause it, read it. Okay? Again, service by publication again. Pause it, read it. All right? But now, let's continue on. Let's go to Rule 3. No, let's go to Rule 4. Let's go to Rule 4. Let's continue on. Okay, so now, as you all can see, we're coming from West Virginia, Rule 3 and Rule 4, okay? The reason why I'm using West Virginia is simple. You know, it's the same in all states, so I just decided to use West Virginia, okay? There's no difference. The rules are the same in every state, okay? It probably won't be titled Rule 3. It might be titled Rule 8 in another state, but it's still the same thing, which speaks on service of process, okay? So I'm sorry that the screen is kind of blurry and the document came out blurry, but just let's continue to read and proceed forward, okay? It states, Rule 3, service of process. The summons and complaint in civil actions shall be served upon the defendant in the same manner as is provided by Rule 4 of the Rules of Civil Procedures for Trial Courts of Record. Subsection 3. Service of process required under Rule 4 of the Rules of Civil Procedures for Trial Courts of Record. 1. General commentary. Let's continue. Rule 3 of the Magistrate Court Rules requires that a summons and complaint be served upon a defendant in the same manner as is prescribed by Rule 4 of the Rules of Civil Procedures for Trial Courts of Record. Rule 4 has 3 basic objectives. First, to set out the factors which must be included in a summons. Second, to describe the manner in which a summons must be issued. Third, Rule 4 establishes the methods by which a summons and complaint may be served on the defendant. Service of process under Rule 4 refers to service of summons and complaint. The broad categorical areas specifically covered in the subpart of Rule 4 include form of summons, issuance of summons, who may serve process, personal or substituted service of process, constructive process, personal service outside state, process served in addition to constructive service, process part of record, proof of service or publication, amendment to process, and time limit for service. The provisions of Rule 4 are discussed in the sections that follow. All right, so let's continue. Because basically they just describe the methods of service above, what we just read. Okay, but let's continue. Rule 4 is a vehicle of providing courts with jurisdiction over defendants and also functions as a notice giving device for defendants. Okay, so Rule 4 is basically how notice should be placed on the defendant. And once the defendant receives notice, then that covers due process. So you cannot go back into the court and say you didn't receive due process when you was actually served the documents and then you decided to simply send them back and not respond and not appear. You waive your due process challenges. You waive your duty to speak when you had a legal duty to do so. But let's continue. Service of process in a manner prescribed by law is an essential prerequisite to a court's jurisdiction over a defendant. Under the general rules, when a particular method of serving process is prescribed by statute, that method must be followed, especially so with reference to service of process on a corporation defendant. A strict compliance with the statute is necessary to confer jurisdiction of the court over a corporation. All right, so let's continue further. Service of process under provisions of Rule 4. This is what we want to read right here. Service of process. Let's continue further. Rule 4 take the form of personal delivery. What we read before. Right? Takes the what? The form of personal delivery. Meaning what? Someone personally appeared and served documents on you. Handed them to you personally and stepped off. That's personal service. But let's continue. Service at dwelling or usual place of abode. Remember I told you all that if they want to do alternative service, then they just simply place the summons, attach it to the door, fasten it to the door of the front door of the resident, and that's considered to be served. Okay? So if you take that off the front door, mail it back, guess what? You just waive your due process challenges. But let's continue. It states service on appointed or statutory agent or attorney in fact, service by mail or service by publication. Okay? So service by mail must be accompanied with what? A certified green card return receipt. So when the post office guy gives you that mail from the agency and they're trying to serve on you, they will have you sign the green card as evidence that you received it. If you simply don't sign the green card, then the post office man will not give you the mail. The post office mail will then decide to send it back to the agency. Then the agency will go to court and say, well, they refused to sign the green card or refused to pick up the mail from the post office. Can we motion the court for alternative service? So they are motioning the court for alternative service, asking the court for another way to properly serve the defendant. The court going to say, okay, well, cool. We know that the defendant's land address is here. Take a copy of the summons, fasten it to the door, have a process server certified that he did fasten it to the door with an affidavit accompanied to it, that justifies proof of service. Okay, that justifies due process. All right, but let's continue further. It states, Rule 4 does not expressly set out the order in which service of process should be made from the options available. It is suggested here that in exercising the service of process options, the following order of service should be followed. So this is the order that should happen when they're trying to serve you. Okay. Personal service, meaning someone must serve you personally. Okay. If that don't work, then they do what? Serve in that dwelling or usual place of abode, right? The next one is service on the appointed or statutory agent or attorney in fact, which would be what? Substitute service. Let's continue. Or service by mail, right? And service by publication. Those are the methods. That's it. That's all. These are the methods that the courts would use to get personal jurisdiction over this so-called defendant. All right. So again, when people tell you to send the mail back, that's going to make your problems go away. No, it will not. If you're on child support or you're not on child support, if you receive due notice, right, and you do not respond, you waive your legal duty to respond, either you're on child support or you're not on child support, that still is what? Establishing jurisdiction. All right. And once jurisdiction is established, then the court will proceed forward and do what? Default you. All right. So again, that's all I'm going to do for today. If you all need my help, hit me up in my email at yahismagnified@gmail.com. Let's get this right wisdom, this right knowledge, and this right understanding. So with that being said again, I say shalom.